I'm here today with George Sinas, CPAN General Counsel and partner at the Sinas Law Firm. George, for over 21 years now, CPAN has been fighting on two fronts, in the legislature and in the courts, to safeguard the rights and benefits provided under Michigan's auto no-fault insurance system, and been the counterbalance to the insurance industry. Can you explain the importance of the judicial front in CPAN's efforts to protect Michigan's auto no-fault system?
Yes, I'd be glad to, and I want to thank you for inviting me to speak to you today about an issue that I consider to be very, very important. I think that the various stakeholders in the Michigan auto no-fault system, particularly the patients and the providers, will agree with me that over the 52-year history of the Michigan auto no-fault law, that the system has experienced a lot of major changes along the way, and many of those changes have not been in the best interest of the patient and the provider. Now, it's important to realize that those major changes did not occur because of the passage of any legislation. Rather, they occurred as a result of appellate court decisions rendered primarily by the Michigan Supreme Court over that period of time. In fact, over that 52-year period, there's only been one major piece of legislation that actually became law that adversely affected, in a significant way, the rights and interests of patients and providers, and that was the 2019 PA 21 legislation. Apart from that, the damage that was done to the system, the setbacks that the system experienced, were because of appellate court decisions. And what does that mean? What's the significance of that? It's very simple. If you want to impact the shape and direction of the Michigan auto no-fault law, you have to participate in the judicial arena, because that's where the action has been, and it's where the action is going to be, with even increasing frequency in the months and years ahead.
Have there been significant recent developments regarding CPAN's involvement in the judicial arena?
You bet there have. So over the 21 years that CPAN has been in existence, CPAN has been very, very active in the judicial arena by filing these things we call amicus curiae briefs. Amicus curiae is Latin for friend of the court. And an amicus curiae brief is designed to explain to the court the greater significance of the legal issues that are before the court in any particular case. And this is important because if the court were only hearing from the specific litigants in the case, their presentation may be so narrow that the full societal and legal ramifications of the court's disposition of the issues may not be fully appreciated. And so these amicus briefs are typically filed by organizations and associations that deal with that particular area of law. Over the last 18 years of CPAN's 22-year existence, CPAN has filed numerous amicus briefs regarding very significant legal issues before the court. And in every one of those cases, CPAN had to file a petition with the court, a motion, asking the court's permission to enter that case as amicus curiae. And almost all of those requests were granted. But in the last 2 years, something very significant has occurred. The Supreme Court has decided to hear at least 10 cases, or at least review 10 cases, no-fault cases, that deal with the PA 21 reforms. And in every single one of those 10 cases, the Supreme Court affirmatively invited CPAN to file an amicus brief. That's a big deal. That is the court realizing that CPAN is a reliable, credible, respected source regarding issues dealing with the interpretation and implementation of the no-fault system. And to me as a lawyer, it really signifies that CPAN over the last 2 years has really come of age as a voice that the Supreme Court wants to hear.
That's exciting. What does CPAN need to do to maintain its level of activity in the courts?
Well, this is where the rubber meets the road. Any auto no-fault stakeholder, particularly providers, need to appreciate what's happening here. If they want to protect the system, if they want to protect their interests and the interests of their patients, then they need to realize they have to continue being involved in the judicial arena. They have to accept those invitations from the high court to make their voice known. And unless they are willing to do that, any opportunity to shape and mold the direction of the law is going to be lost. Now, it's important to keep in mind that this is expensive. You just don't go out there to the amicus curiae tree and pick a brief and send it in to the court. Every one of these cases involves uniquely different facts and legal issues, and so the individual brief has to be carefully crafted, it has to be well researched, it has to be written beautifully so that it will have its maximum impact on the court. And I can tell you from these 10 invitations, the Supreme Court has decided a couple of these cases, and they've decided them favorably, and I'm convinced that CPAN's impact or influence has had an impact on those decisions. But if you want to have a voice, you got to keep your voice. And in this particular situation, you're going to have to raise money to make sure that that voice is maintained and heard.
George, are there any other thoughts you have about this issue?
I do, and it's more of a global thought, and that's this. Here's the bottom line, as far as I'm concerned, being general counsel and a regular participant in CPAN's battles for years and the no-fault system for 40 years. And it's my view that for every auto no-fault medical provider, the adequate funding of the Coalition Protecting Auto No-Fault should be as routine as paying utility bills, employee payroll, property taxes, any routine expense. And I think it's time for everyone to realize if you really care about the system, you should, as the old adage goes, put your money where your mouth is and fund the organization that is your voice in Lansing. It's your voice in the legislature, it's your voice in the courts, and it has now achieved a status of respect that will enable it, if properly funded, to advance the core interests of the patient and the provider. And it's now the time to realize that reality.
Thank you, George.
You bet.